Hi, Phil Hundle here again with a continuation of our condemnation process steps series of videos. We're on step number 9. This is the special commissioner's hearing is held and the award is issued. We've talked a lot about the special commissioner's hearing and how it fits into the condemnation process. It is really the end of the administrative phase. Up until this point, even when the petition is filed by the condemnor, it is in an administrative phase is what it's referred to. No comprehensive discovery can be conducted or other dispositive motions filed at that time because it's in the administrative phase. The special commissioner's hearing and the special commissioner's role is to evaluate the evidence, and the special commissioners are to issue an award that they believe, based upon the evidence that they're presented at the special commissioner's hearing, would fairly compensate the landowner for the taking. And the taking can be anything from, if it's a text dot expansion, taking a fee simple interest, in other words, taking land from you, not just an easement, but land, or a pipeline or power line taking, which typically would be a permanent easement over your land, and also temporary easements or additional temporary workspaces. So they would evaluate at the hearing. Typically, this is what they do, is they evaluate what's being taken, how it is set out in the petition by the condemnor, and then hear from the condemnor's appraiser. And if the landowner's lawyer are attending the hearing, they can hear from the landowner about their opinion as to the value of their property, also their opinion as to the additional impact on their property of the easement or the taking on the value of the remainder of their property. Also, if the landowner and landowner lawyer, obviously this is something that's discussed beforehand with the landowner, will discuss with their lawyer is whether they will have an expert or not at the special commissioner's hearing. I tend to not see many landowners bring experts to the special commissioner's hearings just because it is this preliminary phase. But regardless, the special commissioners will evaluate the evidence and then issue their award. How does that work and how long does it take? And this is just speaking from experience. Normally a special commissioner's hearing can take anywhere from, let's just say, 2 hours to 4 hours. And after each side presents their case, has a chance to cross-examine, put on additional evidence, and then make closing arguments. And once again, this is laid out in another video in a lot more detail. The special commissioners will have a recess and they will evaluate the evidence. And normally it takes about 20 to 30 minutes for the special commissioners to then issue an award. They will let both sides know at the special commissioner's hearing if both sides are there. The question I often get is, as a landowner, do you have to attend the special commissioner's hearing? The answer is you do not. And oftentimes landowners do not attend the special commissioner's hearing, and nor do their lawyers. And the question is, or landowners will often say, well, what are the pros and cons of that? And this is a discussion I encourage you to have with your attorney. There are oftentimes, many times, where we decide it is not worth our while to attend the special commissioner's hearings, and other times it is. Regardless, a key important point to remember is that the award of the special commissioners is inadmissible evidence further in the case at trial. So I see oftentimes landowners probably overemphasizing the result of the special commissioner's hearing. In other words, overemphasizing the award for good or bad. Oftentimes, if it's a favorable award, they think that then the case is over. Well, the case is not over. As we mentioned before, almost 99 times out of 100, I see one party or both object to the award. And so the important point to always remember is whether the award is high or low. In other words, favorable to the condemnor or favorable to the landowner, it will probably be objected to. And whatever that amount of the award was, it will not be known by a jury at a trial. So it's inadmissible evidence. And so that is something to always keep into consideration. So I try to not overvalue, I guess, the impact of a special commissioner's award. So the special commissioners will issue the award, and this is a key part, and this moves on to step number 10, but I want to bring this out because this is critical, is the timeline in which to object to the award. So it's the Monday after 20 days. So we typically explain that to the landowners is approximately 3 weeks. We have 3 weeks from the date that the special commissioners issued the award to object to the award if we want to do so. So step number 9, a lot packed into step number 9 that I've gone over. Hopefully this information is helpful in, once again, better understanding the whole process of condemnation. It is a very different process as opposed to, I will say, normal civil litigation. We have the administrative phase, and then after the special commissioner's hearing, award is issued, and if it is objected to, then ends the administrative phase and begins the normal civil litigation phase, which would ultimately end up or could end up in a trial.